you so much time during mentioning. Next matter.
27, my lord.
Next matter.
Pleasure, Lordship. For listing regular bill application, Lordship.
There is a senior bench you mentioned before the appropriate bench
The punishment
for
is-
listing.
The punishment listing.
Sir,
Listing for listing.
there is a senior bench counsel. Please have a look
The
at
Lordship,
it. So,
the punishment is more than 7 years.
Mr. Counsel, this court has said something. Have you heard it or not? Look into the cause list and find out and mention before the appropriate bench. There is a senior bench also taking the same matter. So any mention for listing should be made before the appropriate senior bench.
What is it?
Yes.
Next week.
Lordship, I beg to mention item number 34, my lord.
30?
CD not received, my lord.
30?
34.
Yes. As prayed for by Mr.
Why, Ali?
Y. Ali, list this matter on Mr. Parashar.
Is an interim mallet on mallet 8th of April.
8/4/2024. Next.
I love
Lordship, I beg to mention for adjournment of item number 48, supplementary list. Item number 48.
এইফালৰ পৰা কিন্তু ভলিউমটো খুব কম আহি আছে দেই মৈত্ৰী ভালকে শুনা পোৱা নাই মই ক্লাছটোৰ কাৰণে নেকি নাজানো আৰু ইয়াত এচিটো কাম কৰা নাই স্পীক লিটল লাউডাৰ কাউন্সিল
Lordship, I beg to mention for item number 48.
48
Adjournment.
supplementary
Yes, Lordship.
as prayed for on behalf
Lord,
as
I'm-
prayed for by Mr.
Lord, I'm appearing for the petitioner, my lord. Only thing is that your lordship has substantially heard the matter. It was regarding the transfer from Nazira to Jorhat, my lord. Only thing required was that I was required to file an affidavit on my current health status, which I had filed, and now they are seeking for adjournment.
We need some instruction from our party, and they're supposed to come yesterday.
when we can give you only till Wednesday
Maybe on Thursday, my Lordship.
Thursday Mr. Goswami as prayed for by Mr.
M.H. Ali.
M.H. Ali with consent from the other side list this matter as fixed item on Thursday.
Deeply honored.
Next.
Your Lordship, I beg to mention item number 36.
36
Matter may be adjourned for the day. We fix up the one.
36
36 CD received.
CD is there Mr. Parashar in 36 CD is there
CD received, but CD is not up to date.
very well your name
S. Abdullah.
as prayed for by MS
S.
S. Abdullah learned counsel for the petitioner list this matter on
Up to date CD on my lord 5th.
5/4/2024 in the meantime up to date CD be called for
Interim.
next interim if any shall continue till then Mr. Mahajan there is a senior bench
No, not for listing, my lord.
Yes.
My colleague had mentioned the item, my lord, 227, my lord. Because the case diaries, my lordship has given a date, my lord. What has happened here, my lord? He's a doctor, my lord. He's a
Mr. Parashar before second any date possible
It can be taken up, my lord, because he's a IBF doctor, my lord.
when do you want it
It can be taken up today, my lord. Lordship has seen the FIR last occasion, my lord. But prima facie,
no but the CD has not come right Mr. Parashar
it can be taken up. My lord. Let the
no
matter reach, my lord.
after you
Let-
on
let the
Friday
matter reach, my lord.
on
He's an
Friday
autistic child, my lord. That is why I
Mr.
find-
Mahajan without CD we will not grant you anything
my lord. Let
so
the
let
matter
it
reach,
be
my
on Friday in the meantime Mr. Parashar you produce the CD in
Well,
item
kindly, my lord.
27 give the date of
He's an
Friday
autistic child, my lord, kindly.
all right Mr. Mahajan next
Bye.
Mr. Mahajan order is passed next
Kindly, my lord, autistic child he has. I wouldn't
next
tell him.
next
No pleasure.
May it please your lordship. My lord, I beg to mention item number 31, my lord. Probably case diary is not there.
31
31.
yes
31 mallet sheet submitted, my lord.
Mr. Das when do you want it
Interim is there, my lord. Charge submitted, interim is there.
you want when do you want it
It can be disposed of today itself, my lord.
so but why are you making a mention then
I did not know. I thought that case diary was not available.
next
My lord, another prayer, my lord. I pray for listing of 2 ABs, my lord. What happened was that, my lord, on the last
Sorry?
occasion, anticipated bail applications, my lord. It was last
For listing?
15th, my lord. Case diary was not there. Interim was there, but
No,
interim
but
was not
for
done.
listing, you make a mention before the appropriate bench.
But this matters pertain to this bench.
Is it? The registry will verify.
Court number 14.
But it was last listed on 15, my lord. In this
Mr. Parasar, is this case tied up with this bench? Have I
Yes.
passed any order in that in relating to that FIR?
Yes, my lord. But what happened on 15? It was listed.
মই
Interim
এইটো
was not
ভেৰিফাই
extended.
কৰি
That
পেলাই
is the
allow
only
কৰিম।
limited prayer, my lord.
যদি মই ল'ব লাগে তেতিয়াহে দিব যদি because that
Only to continue the. Only to continue.
verify কৰে নহলে নহয় all right
Highly obliged.
বিৰাট দিগদাৰ কৰিছে একেবাৰে শুনা পোৱা নাই দেই একেবাৰে শুনা পোৱা নাই এচিটো দিছে ইয়াত
My lord, in this case, my lord, the petitioner, my lord, is
1 second, please.
For 232 days loss. 237 days loss. My lord,
yes
the petitioner behind the bar, my lord, last for my lord 237 days lordship. So in the under trial prisoner lordship, my lord, allegation is my lord some to
366 no 320 302
Already
Yes.
substituted.
My lord, already 8 witnesses have been examined out of 31. My lord,
Mr. Parashar
Scan copy required to verify, my lord.
let the scan copy of the
Short
LCR be called from the court of session judge
Session judge not Lakhimpur.
North Lakhimpur through the registry list on
My lord, one
List
my lord,
on
bail
date.
application, you lordship disposed of lordship.
list
That
on
is
date
20.
next
Ketia দিছে বোলে?
next
My lord, short date may be given lordship.
next
How like that?
Date, please, your lordship. Lordship, this is a 439 bail application, 34 days, lordship. 392 is their lordship. Can you call for the case diary, lordship?
call for CD list on
My lord, North Lakhimpur, my lord, on 8.
8/4/2024
Highly obliged.
May I please, Your Lordship?
Yes.
439 application, my lord. The petitioner was arrested
307
on 326, my lord.
326 307 CD list on
My lord, Kamrup, my lord, on 4th, my lord.
4/4/2024
Obliged.
দিয়ে দিয়ে 67 টো লৈ
May I please, Your Lordship?
417 366A
My lord, yes, my 366 is there, my lord.
Mirachar police station case diary
May I pay
call for
a
case
short
diary list on
Bongaigaon, my lord, 4.
4/4/2024
Obliged.
Item 6.
yes item 6 CD list on
392, my lord, from Nagaon, 5th of April.
it's all right Mr. Bharadwaj we are calling for CD at this moment and date
Since the allegations are not kept,
short date
3rd,
3/4/2024
Item 7.
may I be-
yes Mr. Mahajan
Item 7 can be taken up to item 28.
huh
Item 7, my lord, can be taken up to item 28, my lord.
item 28 CD is there
Yes, my lord. Co-accused, my lord. Obliged, my lord.
yes next 8 নেকি নাই এইটো একেলগে ল'বলৈ দিছে 7 আৰু 28 টো 28 ৰ সময়ত ল'ব দিছে same affair item 28 ৰ সময়ত একেলগে মাতি দিয়া ঠিক আছে item 8 টো মাতি দিয়ক এবাৰ
Item 8.
May I please, Your Lordship?
yes transfer petition
Yes, Lordship. On
Transfer
the
from?
CRPC, from the Learned Court of Kamrup Metro at Guwahati to any competent court at Dibrugarh district.
why
Lordship, the respondent petitioner number 4 and 5, Lordship, may kindly see, are the father and mother of the petitioner number 1, who is the husband of the agreed
when is
party.
the next date
Next date is tomorrow, Lordship. In the Learned
we
Trial
will
Court.
issue notice right now
Lordship, may kindly see the page number 46, Lordship.
page number
46.
46
46, Lordship. Lordship, this is the medical report of the father of the petitioner number 1.
yes
He has suffered a brain stroke, Lordship. On
all right at this stage we are not going to stay it's a transfer petition heard Mr.
M. Ahmed.
M. Ahmed, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 407 of the CRPC praying for transfer of the proceeding of the DV case number 177/2023 pending for disposal in the Learned Court of Kamrup Metro, in the Learned Court of JMFC Kamrup Metro at Guwahati to any other competent court situated at Dibrugarh district of Assam. Stop. Issue notice returnable on?
Lordship, I have a humble prayer, Lordship.
Returnable on? Short
2 weeks.
2 weeks. Returnable on 2 weeks. Stop. Mr. D. Das accepts notice on behalf of the state respondent. Steps in respect of respondent number 1 by registered post AD. List. Moitri, after 2 weeks at the date, dear.
10th of April.
List on 10/4/2024.
Lordship, I have a humble prayer, Lordship. The petitioners, there are many legal medical issues, Lordship.
That's all right. We will see after they appear.
Proceeding
Next.
the state, Lordship.
Next.
Item 9.
Deeply obliged, Lordship.
Criminal revision lordships. Criminal revision lordships.
Yes.
For Zimma of a vehicle lordship. Petitioner is the registered owner of the vehicle lordships. And impugn order lordship, that is page 22 lordships.
Page
22. That is type copy lordship.
Yes. Yes.
Petitioner is represented, received the report from the IU stating that the vehicle shall be required for investigation as the driver of the seized vehicle is
The
absconding.
cattle have been recovered.
Lordship.
Cattle have been
Lordship,
recovered.
that is already handed over to the
You are the registered owner of the
lordship.
vehicle.
Lordship.
Is the
Let him submit the papers before the IO on verification and
And
execution
the
of
petitioner
bond.
also got interpreted.
so we'll dispose of this court will dispose of it with the direction that you file the requisite application before the IO. Let the IO verify and dispose of
Lordship.
in accordance with law
Lordship.
457. Right. Heard Mr. M. Hoff, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. This is an application under section 397/401 read with section 482 of CRPC 1973. Assailing the impugned order dated 13/2/2024 passed by the Learned Subdivisional Judicial Magistrate M. Gaupur Viswanath arising out of Gaupur PS case number 204 of 2023 registered under section 120B/379 of the IPC. Read with section 11(1) small a, b, c, d of Prevention of Cruelty to Animal Act, whereby the Zimma petition filed by the petitioner for custody of the vehicle bearing registration number AS05 capital C 1655 was rejected. Stop. The case of the petitioner is that the petitioner is the registered owner of the seized vehicle. And his vehicle was seized in connection with the aforesaid case alleged to have been used for transporting illegally cattle. Correct? Cattle. Sorry. Stop. The petitioner has filed an application before the court of SDJM within bracket M. Gaupur for custody of the said seized vehicle.
Lordship.
Stop. The court of SDJM M. Gaupur by order dated 13/2/2024 rejected the said Zimma application.
Lordship.
Stop. Then you write, it appears that the driver of the vehicle is absconding, and because of the same, the IO has submitted a report that the seized vehicle shall not be released to the registered owner. Stop. Keeping in mind, no, don't say keep in mind. It appears that the court of SDJM, don't say court of, it appears that the magistrate court has not taken into considerations the parameters required under section 451 for disposing of a Zima application. Stop. Accordingly, this court is of the considered view that this criminal revision petition can be disposed of with the direction that the investigating officer shall file a report fresh as whether the vehicle otherwise is required for investigation, and if not, whether the same can be released in accordance with law. Stop. Pursuant to such report, the magistrate court shall dispose of the application afresh in accordance with law. All right, within a period of 2 weeks from the date of receipt of the report from the investigating officer. With the aforesaid observation and direction, the criminal revision petition stands disposed of. Next. Next. 10. Asset. Yes, it's there. Khali white tree. White. I don't look here.
None appears.
The porter managers in item 10, anyone appearing? None appears for the petitioner when the matter is called. List after 4 weeks on a date to be fixed by the registry.
10.
Item 11. You are appearing in item 11?
Yeah. My pleasure, madam.
Yes.
This is a revision matter against the matter order dated 19/2/2023. Page matter. Page 35. The impugn order matter.
Jima.
Yeah, Jima matter.
Where is the order?
Order is page 35 matter. My Jima.
Yes.
Petition was elected by the trial court matter. Against that order, I came before the lordship matter. Page 35.
Jima of what?
Jima, my lord, is very one, my lord, that is regarding Jima of the jewelry shop, my lord. Jewelry shop, my lord.
Notice.
My jewelry have been sealed by the corporation.
Mr. Das, I'll issue notice that this
Notice will be required.
Yes, nothing else. This is an application under section 401, read with section 397 of CRPC, seeking quashing of the order dated 19/2/2024, passed by the SDJM within bracket S number 2, Kamrup M, Guwahati, rejecting the prayer of the petitioner for Zima of the jewellery shop under the name and style of Moti Jewellers. Stop. Issue notice. Issue notice, returnable 2 weeks. Mr. Das accepts 3 weeks. 3 weeks. Mr. Das, you are accepting on behalf of 3-4.
My lord, 3 I cannot. 3 I cannot. 4 I can.
Who is appearing for 3?
1 and 4.
Anyone from state here?
Deputy Commissioner, my lord.
Deputy Commissioner, Guwahati Municipal Corporation. Anybody?
I will accept.
Mr. D. Das accepts notice on behalf of the respondent number 3 and 4. Stop. Registered post AD in respect of respondent number 1 and 2. List after 3 weeks and a date to be fixed by the registry.
I'm sorry, Lordship. Item number 10, Lordship. I was on name in court number.
Order passed. We'll put your name. You give your name to the court master.
Lordship, I'm sorry, Lordship. The display is not showing.
No problem. You give your name. We'll record your name. Next matter.
Item 2.
Yes, Mr. Jain.
Yes, my lord. My lord, 482, my lord, we are passing for the FIR, my lord. Allegation under section 406, 409.
Where is the FIR?
FIR at page, my lord, with all respect, my lord, relevant portion of the FIR, my lord, at page 25, my lord. In brief, my
25?
lord, the allegation against the manager, my lord, that he has issued and sanctioned some loans account without following the without following
When is the next date, Mr. Jain?
My lord.
Next date.
Next date. No, my lord, under investigation, my lord.
Oh, this is under investigation.
Yes, my lord.
We will issue notice. We are not going to. There seems there are allegations, so we are not going to give you
My
any
lord,
stay today.
With all
Let me
respect,
issue
my lord,
notice on the
I
next
want to
date.
submit one thing, my lord.
Yes, Mr.
That
Jain.
all the accounts, as mentioned in the FIR, my lord, were our standard account. And out of the 9 accounts, my lord, 6 accounts were liquidated.
Very well,
my
Mr. Jain. You understand the limitation, this code exercise under section 40, right?
My lord.
So we are not going to go into the genuineness or not genuineness of these
My lord.
allegations right
My lord,
now.
my lord.
Heard Mr. S.K. Jain, learned counsel for the petitioner. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 482 of the CRPC for quashing the impugned FIR in connection with capital BI within bracket EO PS case number 11 of 2023, registered under section 120B, 420, 406, 409, 468, 471 of IPC. Stop. Issue notice, returnable 2 weeks. 2 weeks. Mr. Das accepts notice on behalf of respondent number 1, registered post AD in respect of respondent number 2. List. You want a
My
fixed
lord,
date?
till the returnable.
You want a fixed date?
My lord, my lord,
List. Do we to Haftar episode?
Till the
Interim shall
returnable,
be
my lord.
considered on the next date. 1/4/2024.
My lord, till the returnable, my lord.
Next.
May I please, my lord, this is an application under section 482 for quashing of NBWA, my lord. Kindly 10 days time. be given.
NBWA?
My lord. I will appear before the High Court below, my lord. Only 10 days time.
Where? Which is the order?
My lord, impugn order is at page number 20, my lord. My lord, I am fairly submitting there is no infamy in the...
From 2018 you
My
have
lord.
not appeared.
My lord, I was out of station, my lord.
From 2018.
My lord.
And you are on bail.
My lord.
Which is your bail order? We are not inclined to give you anything. You want notice or you want dismissal today? Tell me.
My lord, page number 20 itself, my lord.
Mr. Counsel, do you want the notice or you want me to dismiss this case? Only, I'm not going to give you anything more. 2018, you have
My
not
lord.
appeared.
My lord.
And you have violated the terms and conditions of your bail.
My lord, kindly kept in abeyance for 10 days, my lord. I will appear before the lord. Only kept in abeyance, my lord. Only kept in abeyance, my lord. I will participate in the trial, my lord.
You will not be appearing for years and years, and then you come under 482 before the High Court, and you want us to give you a channel to go and appear.
My lord, then I
Until
will
then,
withdraw.
we'll keep it. No, sorry, inherent powers are not exercised for these purposes.
Then I will withdraw, my lord. Then I will withdraw,
Yes, you withdraw.
my lord.
In item 13. Your name?
A. Paramanik, my lord.
Mr. A. Paramanik, learned counsel for the petitioner, submits that he has instructions to withdraw this criminal petition. Stop. In terms of the aforesaid endorsement, the criminal petition stands disposed of on withdrawal. Stop. On top, you also say, heard Mr.
Hello.
D. Das, learned APP for the state respondent. 13 to disposed of. There. To disposed of. তেওঁলোক আহিছে যদি AC আৰু ভইচটো মানে ইমান ক্লিয়াৰ নহয় আহিছে কোনোবাজন just 1 second Actually, I'm not hearing the counsel for the petitioner properly from that side. That is why I've called the technician. It's not very clear today. Yes, Mr. Counsel.
Lordship, well, this petition filed by the petitioner to drop the criminal proceeding, against the petitioner. Because, my lord, so far FIR is concerned, there is no any allegation against me.
This is a quashing petition.
Quashing, my lord, particularly for the petitioner, drop the proceeding, and so far the FIR is concerned, and there is an affidavit also filed by the victim, my lord.
Filed by the?
By the victim, my lord, informant. And
we'll issue notice then. It's sexual harassment. We'll issue notice right now.
And my lord, the respondent number 2 filed a affidavit in bail petition, and she stated that I am not.
Respondent number 2 is not before this court today. Anindita, right?
But I have annexed, my lord.
Very well. So we are issuing notice.
Till then, my lord, interim prayer maybe. Because, my lord.
No. Allegations are there.
Allegation against, my lord, FIR, my lord, against, my lord, name accused, Sofiq Alam Ahmed.
Where is the FIR?
FIR, my lord, page 10, my lord. Very simple FIR, my lord, against the Taylor. Taylor name is Sofiq Alam, and I am the owner of that tailoring shop. And there is no any single whisper against me.
Mr. Das, there is not. Who is Najim Ali and what is the name of the tailor?
Tailor name is Sofiq Alam Ahmed.
Yes, at page 11. And why is Najim Ali arrested here? Because
he was the owner of the shop.
Owner of the shop. All right.
And
where is the affidavit?
Affidavit page 17, my lord. In the bail application, she filed this affidavit. Paragraph 1. That after receiving the copy of bail application, I do hereby submit no objection if the petitioner released on bail, as the petitioner not involved in this case and he is not innocent. I have not cited his name in the
Heard Mr. K. Bhuya, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. This is an application under section 482 of the CRPC seeking to drop the criminal proceeding against the present petitioner in connection with Bokhistor PS case number 44 of 2024 under section 354 capital A1 stroke 354B stroke 34 of IPC. Stop. Mr. K. Bhuya, learned counsel for the petitioner, submits that the FIR is against one Sofiq Alam Ahmed, and there are no allegations against the petitioner. Stop. He further submits that the informant, by swearing an affidavit which is annexed as Annexure 2 to the criminal petition, has stated on oath that the petitioner is not involved in this case and he is innocent. Stop. Issue notice, returnable 2 weeks. Mr. D. Das accepts notice on behalf of respondent number 1. Steps by registered post respondent number 2 within the period of 2 days.
interim prayer, my lord.
Heard interim prayer. Stop. It appears that there are no allegations leveled against the petitioner in the FIR, and also from the affidavit enclosed as Annexure 2, it appears that the petitioner has deposed on oath that the petitioner is not involved in the offence alleged. Stop. Accordingly, a prima facie case is made out for grant of interim relief. Stop. As such, further proceedings against the petitioner in connection with FIR, in connection with the FIR in Bokhista PS case number 44/2024 shall be stayed until further orders.
High level.
List accordingly. কি এসি দেখুন ঠান্ডা ঠান্ডা হয় না আমি কি কেনেকে কাম কৰিম
Item 15.
What's up? This is an application under section 482 of CRPC also.
Yes,
Now
Mr.
crossing the proceeding pending.
For?
Crossing the proceeding pending before the Special Judicial Magistrate First Class, Kamrup Metro, Your Lordship. This is a case under DV Act, Your Lordship.
Yes.
The complaint is at page 12. It
Yes.
starts from page 12 and runs up to.
Will issue notice. Heard Ms. Dr. R. Sharma, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Das, Learned Counsel for the.
We are
Learned
not party. We are not party.
You are not a party.
Complaint case.
Don't say heard D. Das, huh? Sorry, Marshma. This is an application under section 482 of CRPC for quashing of MISC miscellaneous within bracket DV case number 239 of 2023 pending before the Special Judicial Magistrate Kamrup M at Guwahati. Stop. Issue notice returnable 2 weeks. Steps by registered post AD within a period of 2 days. List accordingly.
If your Lordship is pleased, stay in it.
No.
Until the
Next.
Item 16.
Yes, Miss Som.
May it please your Lordship. This Jimma petition, Lordship. Your petitioner before your Lordship is a senior citizen. He is a decorated senior leader of AGP Assam Corporation. He happens to be the president, Lordship. Due to some political really affair was lost, saying that some inputs are given in the social media that maligning the reputation. That was the content. So this petitioner, he was taken into custody, and while taken into custody, without having any search warrant and all, the police personnel they searched the house of and they took all the household belongings, including all gadgets, equipments, whatever for the purpose of the business, household, CCTV, all they have.
This may be required for the purpose of investigation.
Lordship,
I do not know because.
No, because at page 28, this is the order under challenge, Ms. Som.
Yes, Lordship. And Lordship, may I place that 8/8/2023 this affair has been lodged.
All right, we'll call for the report then.
Yes, and as per Sundarbai Ambala, Lordship, they have to hand over me all articles within 15 days of the registration of the case. It's been more than a
Heard
year.
MST Som, Learned Counsel for the petitioner. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. This is an application under section 482 of the Code of CRPC 1973 for assailing the order dated 23/11/2023 passed by the court passed by the Chief Judicial Magistrate Hosai rejecting the Zimma petition number 1786 of 2023. Stop. Issue notice. Notice is required, Mr. Das. Only state. No, right. Issue notice. Mr. D. Das accepts notice on behalf of the state respondent. Stop. Let the
Notice will be required. Respondent number 2 is here.
Where is I can't find respondent number 2 in my copy. There is only one.
Page 3 below.
Yes, because
Page
Who is
3.
this? Page 3.
This is
Respondent number 2 to phone.
what respondent number 2 আছে one has There's Som, there is only state respondent,
yes,
correct?
Lordship. Yes,
All right.
Lordship. He is having a wrong petition.
All right.
Same person, 2 petitions.
Two petitions,
So,
one-
All right. Notice you have said. Then say let the report from the jurisdictional IO be called for. Stop. List of accordingly.
My lord, after some time, my lord, for the time.
What is this?
NBW issue against me, my lord. After some time.
Why?
The report is not there, my lord.
All right, after some time.
Hello.
Iftikhar. All right.
Item 18.
Yes.
Back to the lordship. Here, my lord, the interim maintenance.
Just one sec. Iftikhar. You pass me here, Silva. Yes.
My lord, here interim maintenance has been granted without following the mandate of the Honorable Supreme Court. Your lordships, kindly see the page 28 annexure 4. This is the impugned order.
Come. Page
28 annexure 4. That is 13/2/2024.
Yes.
On that day, my lord, we filed an application for adjournment to file an application for filing the written statement, and it was allowed. But on that particular date, my lord, interim maintenance has been granted to the respondent, my lord.
You are for?
I am for the husband. And that cannot be, because it is required that, my lord, some affidavit disclosing the asset and liabilities must be furnished, and it is the mandate of the Supreme Court. That is
Even for interim?
My lord, so far the proceeding, my lord, I cannot, but so far the payment of maintenance, my interim maintenance, that may be stayed. Because page 32, your lordship, kindly see last paragraph 65. This is the page 32. Last 60. The party
We will issue this court will issue notice and give you a short date. On the next date, the interim prayer shall be considered.
Because the next
Look,
day is the
all right,
political
let
statement.
the other side also appear.
It is the violation of the, because we have not disclosed the assets and liabilities.
Very well. I'm keeping the issue open for the next date. You are N. Hawk. Heard Mr. N. Hawk, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. This is an application under section 482 CRPC.
We are not there. In 18.
State is not there.
No state, huh? This is an application under section 482 of CRPC. Seeking quashing of the impugned order dated 13/2/2024 passed by the Principal Judge Family Court Borpeta in FC Criminal Case number 598 of 2023, whereby the petitioner has been directed to pay the respondent a monthly interim maintenance of Rs 2,200 with effect from the date of institution of the proceeding, i.e. from 19/8/2023, to pay 25% of the total arrear interim maintenance in every month till full recovery. Stop. Issue notice returnable after 10 days, Moitri? After 10 days of the date. Returnable on 9/4/2024. Stop. Steps by registered post AD. Interim prayer shall be considered on the next date. List accordingly. Yes, Mr. Borthakur.
To application, Your Lordship. Silently proceeding under Domestic Violence Act, Your Lordship. DB
Yes.
case number 197 of 2023.
Where is the case?
Lordship.
Where is the petition?
Petition is, Your Lordship. I have annexed it, Your Lordship, at page 31, Your Lordship. Your Lordship, if Your Lordship comes to the petition, Your Lordship will find we are not in the shared household, Your Lordship. This is admitted, Your Lordship. First page, Your Lordship, page 31. the respondent number 2 and respondent number 4, Your Lordship.
Mr. Bhattakur, let them appear.
Lordship. Otherwise, Your Lordship, within the meaning of section 2Z, Your Lordship, we
Let
don't
them appear, then we will consider the interim, Mr. Bhattakur. Heard Mr. S. Bhattakur, learned counsel for the petitioner. Stop. Also heard Mr. Didas, learned APP for the state respondent. Stop. This is an application under section 482 of CRPC for quashing the proceedings in connection with DV case number 197/2023 filed under section 12 of the Protection of Women from Domestic Violence Act 2005, pending before the Chief Judicial Magistrate Kamrup M.
So far as the petitioner is concerned.
So far as the petitioner is concerned. Stop. Issue notice, returnable 2 weeks. Mr. Das accepts notice on behalf of R1. Steps by registered post within a period of 2 days in respect of R2. List after 2 weeks on a date to be fixed by the registry. Interim shall be considered on the next date. Yes, Ms. Chaudhary.
May it please your lordship. Completely false case has been registered against the petitioner, my lord.
Yes.
Miss DV case number 148 of 23.
Yes.
Your lordship will find the. I've challenged the proceeding there. The Miss DV petition is at page 25. Lordship, if I may read few lines. Page 26, lordship. The averment is that the respondent is a prominent businessman of the area having strong political connection. Thereafter, she tries to make out the case of domestic violence so as to specify that there was physical abuse, mental abuse, etc. And lordship, now this is falsified by the documents that has been placed before your lordship.
By you?
Yes.
By you?
Yes, lordship.
Ms. Chaudhary, at this stage, let's issue notice because otherwise the law is clear. At this stage, this court will not go into the documents that you have brought in. But anyway, we'll issue notice. After they appear, we will see if anything is to be done. Heard MS B. Chaudhary, learned counsel for the petitioner. Stop. Is state a party?
Yes, lordship.
Heard Mr. Didas, learned APP for the state respondent. Stop. This is an application under section 482 CRPC for quashing the proceedings in connection with miscellaneous DV case number 148/2023 pending in the Court of Judicial Magistrate First Class, Kamrup. Stop. Issue notice, returnable 2 weeks. Steps by, extra copies, Mr. Das, R1, registered post AD, R2 with a period of 2 days. List after 2 weeks on a date to be fixed by the registry. Interim on the next date.
Interim shall be considered on the next. Great.
My side. Yes, Mr. Mahajan.
Lord, this is a charge-sheeted matter, my lord.
21.
Yes, my lord.
Charge sheeted.
Under section 395, my lord, what has happened here, my lord? Summons have been issued to me, my lord. Charge sheet was laid in the year 2020, my lord. Summons have been issued in the year 2023, my lord.
Summons were issued in
23, my lord.
23.
Charge sheet is at page 18, my lord. Charge sheet is dated, my lord.
You are not aware?
No, my lord.
After the summons?
My lord, I was aware, my lord. I was aware regarding the case, my lord. My anticipatable in the year 2018, my lord, was rejected, my lord, by the Honorable High Court, my lord. After that, my lord.
You are ready to appear?
I'm ready to appear, my lord.
Mr. Das?
I have annexed a similar order. 2023 summons.
Heard Mr. 21.
N. Mahajan.
Sorry?
Sorry, N. Mahajan.
Heard Mr. N. Mahajan, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for grant of pre-arrest bail to the petitioners, i.e. Rasid Ali and MD Sadiq Ali, who are apprehending arrest in connection with PRC case number 527 of 2021 arising out of Bipuria Police Station case number 206/2017. Stop. Only summons issued, not
Summons
NBWA,
issued,
right?
Someone, no NBWA.
Because now that case, just day before yesterday, one judgment has come from the apex court where in case
PNA
of
is there, my lord.
yes, no anticipatory bail.
PNA, my lord.
PN, correct.
Summons is at page 26. my lord.
Page 26.
26, my lord. I appealed through my pleader, my lord. Page 26, my lord.
Procedurally, no? Procedurally, no.
Procedure.
Page 26.
26.
26.
It is submitted at the bar
Order.
that charge sheet has been filed in the instant case wide CS number
258
258
oblique 2020
oblique 2020
dated 27/9
dated
27/9
9
2020
2020. Stop. Mr. N. Mahajan, Learned Counsel for the petitioner, submits that
the occurrence of the year 2017.
that the petitioner is willing to appear before the trial court,
Committal court.
before the committal court on the next date fixed.
15/3.
Stop. Next date is
15th of March, madam.
15th March.
15 March is over.
15th March is over, my lord.
That's what. Any idea what is the next date?
It will be the next 14 days, but I suppose that.
Then I'll say within 10 days.
10 days.
Is willing to appear before the committee court. Stop. Considering the aforesaid submission and considering the aforesaid endorsement made by the Learned Counsel for the petitioners, this court is of the considered view that this anticipatory bail application can be disposed of with the direction that the petitioner shall appear before the Learned Court of Judicial Magistrate First Class, Lakhimpur, not Lakhimpur, within a period of 10 days. Until then, he shall not be arrested. Stop. Upon his appearance, the committal court is at liberty to consider the prayer for bail at its own on its own merit. Stop.
The committal court would not be able to grant, my lord, because life punishment is there, my lord.
Shall this
I'll appear before the trial court, no sessions judge.
You just simply say, with the aforesaid observation and direction, this petition stands disposed of.
My lord, Lordship can directly appear before the trial court.
That we are not saying. You
Case
appear,
is not committed.
you first appear before the committal court. Committal court will proceed in accordance with law.
Obliged, my lord.
Upon his appearance, committal court is at liberty to proceed in accordance with law. Disposed of, huh? Yes.
With resolution. So this is basically a land dispute, my lord. My
land
husband,
dispute.
Yes, my lord. My
FIR.
FIR, my lord. Lordship, before that, Lordship will kindly come to page 19. That was the FIR which was lost by me, my lord, which is in the earlier point of time. It was lost by the petitioner number 3, my lord.
Yes.
As many as 8 accused were named. Lordship will kindly come to page 20.
Yes.
With due respect, I beg to inform you that all the above named persons are very violent and also non-social persons. These accused persons have been torturing my family since long. Today on 3/3/2024 at about 1:30 p.m. when I was alone in my father's house, taking the opportunity, the accused persons entered into our house unauthorizedly and started to destroy the house and other things of our house with dao and kutar, etc. Then the accused number 1 entered me into my room and against my will and attempted to rape by pushing me to the ground and touch my body and forcefully remove my clothes. When I tried to raise hue and cry, the accused number 1, in order to kill me, attacked me, and when I tried to resist, I got injured by cut over the left eye and lots of blood came out from the cut. The accused persons not only committed the said illegal acts, but also destroyed both the houses in my campus and also looted 65,000 from the table, gold chain of 1 bori, gold marquee, etc.
Yes, where is the other FIR?
Lordship, this was registered at Milord, Borbetta PS 105 or 24, Milord.
Yes.
As a counterplus to that, Milord, Lordship will kindly come to page 15.
Yes. Same date.
Same day, Milord. But in fact, Milord, when they went to Milord lost the FIR, Milord, the two persons were...
From where can you show that yours was
Milord, it's
prior?
Lordship, page 16, Milord, Borbetta PS case number 106. Their FIR is, Milord, was registered as Borbetta PS case 104 of 6 of 2024, Milord.
There is 106.
Page 16, Milord.
Yes, that is their FIR.
Lordship. And my FIR, Lordship will kindly come to page 21.
Yours is 21.
Borbetta PS 105.
Okay.
And in fact, Milord, only section which is Milord non-billable is up to 326, Milord. And Milord, after the arrest were made, Lordship will kindly come at page 27 and 28. The injuries are all simple in nature. 326 is not affected.
15. You are which accused?
All,
You're for all.
All.
And who is the person who had lodged Abida Begum, your FIR?
Petition number 3, Milord.
Number 2.
Petition number
Accused number 2, Abida Begum.
Yes, Milord.
She has alleged that the informant tried to rape her.
Yes, Milord. In fact, they were arrested, Milord, and in fact, medical tests were done, which your Lordship will find at page 27 and 28. Only section, Milord, which is non-bailable is 326. Milord, no injury. No external injury.
Mr. Das,
The cross cases are there, Milord.
let them appear before the IO.
Yes.
Heard Mr. R. Day, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. This is an application under Section 438 CRPC seeking pre-arrest bail to the petitioners, i.e. 1, 2, 3, 4, 5 and 6. Page number 2, 3. Okay. Who are apprehending arrest in connection with Borbetta Police Station case number 106 of 2024 dated 4/3/2024 under section 147, 148, 149, 447, 448, 326, 325, 427, 506 of IPC. Stop. The case of the petitioner is that there was a land dispute going on between the petitioner and the accused, petitioner and the informant side. In connection with the said land dispute, the petitioner had filed an FIR on 3/3/2024, and after the lodging of the petitioner's FIR, the informant filed the present FIR in connection with which the petitioners are apprehending arrest. Stop. Call for CD fixing on after yes, Mr. Das, when?
21st of April.
22 4/2024. Stop. Considering the facts and circumstances of the case, this court don't say this court. It is provided in the event of arrest of the petitioners named above shall be released in connection with the aforesaid case on interim pre-arrest bail of rupees 30,000 each, satisfaction arresting authority, subject of course to the following conditions. Give the two conditions. First condition, surrender before 7 days. Okay. Second, inducement. List accordingly.
Declare last. Yes, Your Lord.
Yes, Mr. Jain.
My Lord, 438 application, my Lord, FIR at page 14, my Lord. In brief, my Lord, the allegation against the petitioner, my Lord. Petitioner is the name in the FIR, my Lord. Allegation against that at the time of sanctioning the loan, my Lord, some irregularities has been observed, my Lord. And subsequently, during the period, it is a matter of 2016, my Lord. And during the investigation,
FIR
at page 14, my Lord. Your Lordship may kindly see. FIR at page 14, my Lord. I am reading, my Lord, a relevant portion, my Lord. Paragraph 3, my Lord.
It appears that procedures were not followed, Mr. Das.
My Lord.
Procedures not followed before granting loan. That is the
Yes,
allegation,
my Lord.
right?
Irregularities has been observed.
Let him appear.
My Lord.
Heard Mr. S.K. Jain, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. This is an application under section 438 of the CRPC for granting pre-arrest bail to the petitioner, i.e. Torun Kumar Seal, who is apprehending arrest in connection with BI within bracket EOPS case number 03-2016 registered under section 120 within bracket B 420, 409, 468, 471 of IPC. Stop. The case of the prosecution is that the petitioner, without following the procedures, have granted loan. Has granted loan to
Some borrowers, my Lord.
to few borrowers. Stop. Call for CD fixing on
19th of April.
19/4/2024. Considering the facts and circumstances of the case, it is provided.
Objection regarding interim, my objection will be.
It is provided that it is provided that the petitioner named above, in the event of arrest, shall, in connection with the above noted case, shall be released on interim pre-arrest bail, bond of rupees 30,000, arresting authority appearance within, subject to following conditions:
10 days, madam.
10 days, and inducement list accordingly.
Deeply obliged.
My objection will be.
What is your objection?
No, Lord, the 409 is there after economic offense. Banks are.
So you simply say, I heard submissions made at the bar and Mr. D. Das. So.
Obliged, madam.
Make page a lot. So the FIR is of
24.
24. 438 application lordship. FIR dated. This is a 438 application lordship.
Yes.
FIR dated 3/11/2015 lordship.
3/11?
2015. That is Annexure 1, page 10.
Yes.
It was registered under section 436, 427, and 30.
You put a shop on fire.
Lordship. This is the allegation, Lordship. And thereafter, search sheet was submitted in this case, Lordship, in the year 2021, implicating the petitioner as absent.
This FIR is of 2015.
2015, Lordship.
You appear. No, we are not giving you anticipatory at this stage. Let the CD comes.
Someone was issued in the PRC case, Lordship.
Call for CD.
Scan
call for the scan copy of the LCR from the court of Chief Judicial Magistrate Tinsukia through registry. Stop. List on
19th April.
19/4/2024. Yes.
Obliged, Lordship.
An application under section 438 CRPC paying for
Just 1 second. 1 second. No supplementary list किया ना नहीं. वहाँ से आ सकते. Yes.
The FIR in page number 9.
376.
Lordship. The FIR in page number 9, Lordship. May I read, Lordship?
Yes.
Humble submission is that on 7/3/24 in the dark at about 7 p.m. when I was alone.
CD.
Lordship, Lordship, I have a look at the page number 4, Lordship.
We will not go into other page. The
Lordship,
FIR, there are allegations.
Lordship, it's a completely false.
We'll see the CD. This is not a case for interim pre-arrest bail.
Then maybe a short date may be given.
Call for CD. List on
5th of April.
5/4/2024. Next.
5th of April is long date, Lordship.
Next.
Okay.
A2 whole call 37 to.
Here, please, your lordship. Lord, the petitioner is before your lordship against annexure 5 and 6 documents, Lord.
And against annexure
5 and 6, Lord, whereby non-bailable warrant of arrest was issued against the present petitioner. What happened in this case, there were several, as many as 21 accused persons in the incident FIR, and all the petitioners belong to the same family and their relatives,
PNA has been issued.
PNA has been issued, by Annexure 6.
Since when have you not appeared?
I entered my appearance only, only once, and after that, not in the year.
Why?
Ketia.
It was in the year 2018. And after that, because there were 21.
No. You want to withdraw or I'll dismiss? 2018, you have not appeared. Then you have violated the terms of the bail conditions also.
This section, in fact, in the case was, the FIR was submitted, and pursuant to the...
You want notice? I can give you notice. Otherwise, I'm dismissing it.
Because on any condition, I would appear.
No. You're not getting that from this court. You want to withdraw? Issue notice,
Because
returnable 2
may I
weeks.
place only one thing?
Do you need the CD?
CD, succeeded case long.
Not required.
Summons were already issued.
Mr. Didas accepts notice on behalf of R1, registered post AD R2. List after 2 weeks and a date to be fixed by registry. Next.
Obliged.
For admission, I can
Yes.
By this application, my lord, I have challenged the territorial jurisdiction of the court at my lord, Guwahati. My lord.
Yes, sir.
Have you served? R2 is R. Mr. Saikia, you are appearing for respondent. Number
my
2.
lord. My lord.
That's R2.
My lord, yes, my lord. The case is not maintainable, my lord.
Hmm?
This case is not maintainable. I have brought the judgment of our High Court and...
All right, let me first hear them.
Yes.
My lord, 138 proceeding, my lord. And my lord, the check was presented, my lord, at SBI branch, Pan Bazar, my lord. That can be discernible from page 22.
Page 22, check presented.
My lord.
Yes.
Check presented means, my lord, they have communicated that check was, my lord, dishonored.
Yes.
If your lordship come to that top, the second line,
yes,
presenting branch name, Guwahati branch Pan Bazar, my lord.
Yes.
Now, my lord, she maintains her account at Dhekiajali. This can be discernible from
Who maintains?
that complainant, respondent number 2, my lord. That is it.
Are you trying to say Guwahati branch is not a bank, not an account of the complainant?
Yes, my lord. She is maintaining account at my lord Dhekiajali branch.
Where do I get the name of? But this is the Sabita Thakuria. Sabita Thakuria is R2.
She had the accounts of State
Then
Bank of India or Guwahati.
how does it matter in which bank? You have issued a check to Sabita Thakuria.
Here also.
Correct.
Yes.
So there is a my lord, impediment.
Check is in the name of Sabita Thakuria.
Yes.
So she can deposit where she wants.
My lord, she deposited at Pan Bazar.
Yes.
But my lord, 142 subsection 2 says 42 subsection 2.
Yes.
Is cognizance of offence, my lord.
Yes.
Now kindly come to subsection 2. The offences under section 138 shall be inquired into and tried only by a court within whose local jurisdiction. If the check is delivered for collection through an account, the
This
branch
proceeding is not within the jurisdiction of Guwahati branch. Where is the proceeding drawn?
that Guwahati, my lord. Proceeding is in Guwahati.
So then, what is sorry, Mr. Counsel, this court is not clear as to what you want to show from subsection 2 of 142 because
Yes,
it says
subsection 2 says the
As which
proceeding
court-
under 138.
where will it be filed?
Yes, at Dhekiajali branch, my lord.
Where it says the offence under 138 shall be inquired into and tried only by a court
Yes.
within whose local jurisdiction, if the check is delivered for collection through an account,
Yes,
the branch of the bank where the payee or holder in due course, as the case may be, maintains the account is situated.
Yes.
Here the account is Guwahati branch.
No, she is maintaining a
You see, Mr. Counsel, Mr. A might have 3 bank accounts. You may issue a check to Mr. A. Mr. A may have deposited. The moment Mr. A deposits here, this is and from where it is dishonored under subsection 2 of 142, it will be that court, no?
Come to explanation.
Is there any?
Explanation.
Yes.
For the purpose of clause A.
Yes, which part? Okay.
Explanation. For the purpose of clause A, where a check is delivered for collection at any branch of the bank of the payer or holder in due course, then the check shall be deemed to have been delivered to the branch of the bank in which the payee or holder in due course, as the case may be, maintains the account below.
Presenting branch, Guwahati branch also, the petitioner has a account. He's maintaining. The petitioner is maintaining it. How can you say no?
18. Kindly come to page 80.
Page 80.
Page 18.
18.
Yes.
Yes.
This is the bank account below, and she is maintaining at Dhakiajuli below. Page 18. And while she presented...
Very well, we'll admit and fix this matter for hearing.
My lord, the case is not maintained.
Mr. Saikia, we are fixing it for hearing. You can make your arguments at the hearing stage.
That's the meaning.
Yes.
A similar case came up before this court. That at any branch, if the...
Prima facie, this court is with you, but petitioner will have to hear the point.
Wrong reading is given by my friend. Yes. Lordship, kindly see, let me read this order.
Paragraph 11.
My lord,
Paragraph 11, Mr. Saikia.
Paragraph 11. Yes, my lord. A cursory perusal of the provision makes it abundantly clear that no classification of check as bearer or cost account pays is made in the NIA for the purpose of jurisdiction, and as such, no classification of check can be made for the purpose of jurisdiction, being not provided in the Act. Moreover, from the word any check used in section 138 can be well interpreted that it may be an account, pay or check or bearer check, dishonor of which account of insufficiency of fund or exceed the amount would amount to an offence and would attract the penalty. Next paragraph, my lord.
Yes, Mr. Saikia.
From the Annexure 1 and 2.
Mr. Saikia, just 1 minute. What were you showing from page 18?
Page 18, my lord. This is the...
Mr. Saikia, 1 second.
This is the account.
1 second. What were you showing from there?
This is the account, my lord. She is maintaining at Dhakiajuli and in that...
Where? What is it?
18, my lord.
This is an affidavit filed by whom?
My lord.
This is an affidavit of whom?
Page 18.
No. The document at page 10 is the complaint case.
My lord. Page 10.
Yes, what is this? This is the complaint case.
Yes, complaint case.
Under the NIA.
And page 18 is the part of that complaint, my lord.
Page 18.
Page 18. This is the part of the complaint, my lord. This is the account where she has deposited the check amount.
No, but then how that because in paragraph 6 also it is mentioned this check, the check that has been dishonored is check number 914667.
Yes.
Hekiajuli it is mentioned. Alright, we are admitting it.
Just a minute. Let me read the last paragraph.
Mr. Saikia, let's not do a mini trial at the time of admission. Prima facie, there is a case, we are admitting it. Heard Mr. Your name?
S. Sahu.
S. Sahu, Learned Counsel for the petitioner. Stop. Also heard Mr. R. Saikia, Learned Counsel for respondent number 2. Mr. D. Das, Learned Counsel, Learned APP for R1. Stop. It appears that the petitioner has a prima facie case for hearing. Stop. Admit, list the matter for final hearing on. Give a date. Give a date for hearing.
A short date will be given.
Yes, give a date.
Let it be on second appeal.
On 30/4/2024. Final hearing.
Order dated 18/8/22. Notice was also on the interim pair.
Next.
But that may be.
Please, Your Lordship.
Case diary? Yes.
Lordship, case diary along with the detailed medical report was called for. FIR is on page 7, Lordship, typed copy.
Page?
Page 7, Lordship.
Yes.
With due respect, I would like to inform you that yesterday on 24/2/2024 at night around
Just 1 second. AC to check koi goal control take care ke AC kaam na kore. Nice. Swa. Nije na bon ho jaye. Ta to koi to fix kore ekdam avastha beha goise. Yes, FIR at page?
Page 7, Lordship. May I read, Lordship? With due respect, I would like to inform you that yesterday on 24/2/2024 at night around 11:30 p.m. there is an argument between my husband and a resident of nearly rented house, namely Vicky Kolita. Full stop. At that time, owner of the room, Bosumati Moran, and his son Sunil Borman entered into my room and beaten up me and my husband without knowing the fact of the argument. Sunil Borman kicks me my hands and stomach. Immediately I fell to the ground. I felt pain because of 4 months pregnant lady. Immediately I have been admitted to Hayat Hospital by my husband. Doctor of Hayat Hospital gives me my test. Then my husband took me to Dhirenpara Hospital and from there they sent me all care for test.
Yes, medical?
Medical available.
What does it say? Were you on interim? No.
No, it is 439, Lordship.
439.
Actually, they have wrongly typed it. This is not Sunil Burman, it's petitioner Munin Burman.
Mr. Parasha?
This is not Sunil Burman. They have typed it in the FIR, it is Sunil Burman.
So there is some inconsistency in the medical report as regards the identity of the person?
No. They have wrongly typed it. In the vernacular, this is Munin Burman. Munin Burman is the petitioner.
Typological error is there.
Otherwise, unfortunate incident is that lady got miscarriage, 4-month pregnancy was there. But there are 6 numbers of witness along with the husband of this victim lady. He also stated that yes, there are scuffle between that Vicky Kolita and Munin. During the scuffle,
this lady got
injured by side of bed.
By the side of the bed.
She got injury on stomach, and on the next day, she got that miscarriage was done.
So the scuffle was between the petitioner
and one Vicky.
One
Vicky Kolita.
Not related to the lady.
No, not petitioner. Vicky Kolita and the husband of the victim.
Correct.
And he went to stop that scuffle.
All right. So then, how many days?
13 days, 17 days.
17 days.
Medical report maybe.
Medical
and his statements have been recorded.
6 numbers of witness along with the husband of the victim also. There ultrasound report is there is abortion and 9 weeks pregnancy.
It's an unfortunate accident that happened to the victim. Victim herself has lodged the FIR.
Yes,
The statement of the 6 numbers of witness all are stated that he went to stop the.
While she went to stop.
No. While the petitioner went to stop the scuffling between the husband of the petitioner and Vicky.
And
husband of the petitioner and one Vicky Kolita.
Vicky Kolita. All right. Item number.
Lordship, I am this victim and the victim is the tenant in my residence, Lordship.
Your name?
Lordship, Sunil Burman, Lordship.
No, your name, counsel.
D. Medhi, Lordship.
Mr.
D. Medhi, Lordship.
Heard Mr. D. Medhi, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent. Stop. This is an application under section 439 of CRPC, praying for granting bail to the accused, i.e. Muneen Bormon, Alice Moon Bormon, who has been arrested on
1/3/2024.
1/3/2024 in connection with Dispur Police Station case number 165/2024 registered under section 294, 313, 323, 325, 34, 448 of IPC. Stop. The case of the prosecution is that on 29/2/2024 an FIR was lodged alleging that on 28/2/2024 an argument took place between the husband of the victim and a boy named Vicky Kalita, who was residing at rent house in the same compound. Stop. It is further alleged that the owner of the rented house, that is you.
No, Bosumati
Bosumati Bormon and the owner's son Muneen Bormon, within bracket petitioner, entered the room and beat the victim and her husband without knowing anything, for which the victim fell down on the ground and suffered injury. Stop. Mr. D. Medhi, learned counsel for the petitioner, submits that the petitioner is totally innocent. Stop. He further submits that the petitioner is not involved in the offence alleged. Stop. Mr. K.K. Parashar, learned APP, fairly submits that it appears from the materials collected by the investigating officer that while there was a scuffle between the victim's husband and one boy named Vicky Kolita, the petitioner, when went to stop them, accidentally the victim got hurt. Stop. He further submits that the petitioner's statement has already been recorded under section 161 CRPC, and that the witnesses and the statement of other witnesses have also been recorded. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation has substantially progressed. It further appears that the petitioner is not involved.
Not intentionally.
It further appears from the materials available on record that the petitioner, while tried to stop the scuffle which was going on between the husband of the victim and one boy, accidentally the victim got hurt. Stop. Considering the facts and circumstances of the case, it is provided that the petitioner named above shall be released on bail in connection with the above noted case on furnishing of bail bond of rupees 30,000 satisfaction of
CGM
CGM Kamrup subject to following conditions. Didiba condition dita, and with the above aforesaid observation direction, this bail petition stands disposed of.
Highly obliged.
It কামজি কৰিছে ফেনটো বন্ধ কৰিব পাৰে. Yes, Mr. Mahajan.
Yes, my lord, with all respect, my lord. Here, case diary was sought for, my lord. If the FIR is dated, my lord, it is regarding, my lord.
FIR is at page.
FIR is, my lord, at page.
Which
12.
one are you first doing?
28.
28.
28. My lord, with all respect, my lord, page 12 is the FIR.
Page number 12.
12, my lord. Primarily, it talks about 4 persons, my lord, who committed robbery, my lord, and, my lord, kidnapping, my lord. 365 and 392 are the IPC offences, my lord. FIR itself states, my lord.
Snatching of gold.
Exactly, my
That
lord.
is the
Absolutely,
offense.
my lord. 4 persons, my lord. And those persons' names are apparent, my lord. Lordship would kindly come to page 29, my lord. One forwarding report, my lord. Page 28 starts, my lord. Page 29, chronologically, para 8, my lord.
Yes.
Page 29, my lord. Chronologically, para 8, my lord.
Yes.
There may read it, my lord.
Yes. Yes.
All 3 arrested accused persons, the names are down below, my lord, have revealed that in a group of 4, they kidnapped the complainant when he was standing in front of Dream City Hotel near ISBT and looted from him 2 packets of gold biscuits containing 12 pieces, which they handed over to their 4th associates, accused, whom they called Bhini.
Where are their names? Page 31.
Yes, my lord. The names
Page
are
31 is
exactly.
3 names. What about the 4th name?
Exactly. 4th name I'm giving, my lord. 4th name is, my lord, Bhini, my lord.
Who are you?
My lord, I'm Azmal Hussain, my lord. Nothing to do with the 4, my lord.
Where is the 4th name?
4th name is at page 35, my lord. Grounds of arrest, my lord. Page 35, my lord.
Yes.
The main one, my lord. The main accused person, Ranjit De Bhini, and Radul Power are absconding, my lord. Now,
Yes.
thereafter, Bhini, out of those 4, my lord, arrested on 1/3/24, my lord.
Where do I get that?
Exactly, my lord. In our forwarding report, my lord. Along with us, my lord, that is at
So
page
this
29.
the 4th one has implicated you
Yes,
in his statement.
yes, my lord.
Where is that?
My lord.
Where is that?
Page 17, my lord.
Page 17.
Exactly, my lord. That is chronologically in para 3, my lord. Therefore, there are 2 custodial interrogation is required, very necessary to apprehend the co-accused and recover the looted gold and bear the nexus. That's the language, my lord.
Which part, Mr. Mahajan?
Page 17, grounds of arrest.
All
grounds
the
of
3
remand, my lord.
accused. Now, these 3 accused are which one? The Ranjit De, Bitu Sarkar, Ajmal Hussain.
Exactly.
And you are?
Ranjit De is the 4th person, my lord.
He is the 4th person.
4th person gone, my lord.
And then you are?
I am Azmal, my lord.
This is item number 28.
28.
And in item number 17,
Bitu
7,
Sarkar, my lord.
7 is Bitu Sarkar.
Bitu Sarkar. And my lord, we
So
are
initially 3 people were arrested, and the case was also 3 people and 1 more.
one more.
Correct?
Exactly.
That other person is Ranjit De, not
Ranjit
you.
De. Right.
Now, Ranjit De has implicated the person at item 28 and item 7.
Exactly. We are his, my lord. Yes, my lord. Nothing
What
to do
is
with the
what
crime.
is the allegation of implication?
My lord, so far as forwarding reports are concerned, my lord, my lord, we assist him in buying tickets. My lord,
Where is it?
My lord, that is our defense, my lord. But
Mr.
in
Das?
forwarding report, nothing is there, my lord.
What is against Ajmal Hussain and Bitu Sarkar?
Azmal Hussain, so Bitu Sarkar, this Ranjit Kumar De, they both are associate of Ranjit Kumar De.
These 2.
Exactly.
These 2, who was engaged by this Rahul Pawar to commit the crime. Now, Milord, Ranjit Kumar they says that he after some people were arrested, Milord, he fled away to Kolkata, and Bitu helped him, Milord.
Bitu has?
Bitu Sarkar helped him in fleeing. Milord.
Fleeing.
And he visited him at Calcutta also and gave him rupees 5,000 for Milord.
But for the at the time of
and so far recovery is concerned, Milord, seizure have been made, seized property, seized, Milord, stolen, suspected to be the stolen property from Rahul Chandra Pawar, house of Rahul Chandra Pawar, on being led by his wife. Now gold.
So gold recovered.
Cash money was recovered, and also from Milord this Ranjit Kumar De.
And what is there against Ajmal Hussain? Because according to you, the implication Bittu is that he helped Ranjit De to flee.
Yes, that's the statement of this Ranjit Kumar De.
And what about Ajmal Hussain?
Ajmal, he does not say anything about Ajmal.
So there is no material as of now.
I have not found. The IO says that
all right.
He has been examined.
First, in item number 28, heard Mr. B.M. Mahajan, Learned Counsel for the petitioner, stop. Also heard Mr. D. Das, Learned APP for the state respondent, stop. This is an application under section 439 CRPC for granting bail to the accused petitioner, i.e. Ajmal Hussain, who has been arrested
1st of March.
On 1/3/2024 in connection with Gorshuk Police Station case number 56 of 2024. Stop. The case of the prosecution is that on 12/2/2024, an FIR was lodged alleging inter alia that on 11/2/2024 at about 11:30 am, when the informant received pure gold weight 1 kg 500 gram on behalf of his owner and went from ISBT Bedkuchi to Paltan Bazar, 4 numbers of unknown persons forcefully came in a vehicle and pulled and grabbed the gold articles and dropped him at Khanapara. Stop. Mr. B.M. Mahajan, Learned Counsel for the petitioner, submits that the petitioner is not named in the FIR. Stop. He further submits that the petitioner is totally innocent and has been wrongly implicated in the offence alleged. Stop. Mr. D. Das, Learned APP. Mr. D. Das, Learned APP for the state respondent, fairly submits that there are no material adverse at this stage collected against the petitioner by the investigating officer. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Considering the facts and circumstances of the case, it is provided that the petitioner named above in the event shall be released on bail in connection with the above noted case for on furnishing bail bond of rupees 30,000. Satisfaction?
CJM Kamrup Metro.
CJM Kamrup Metro. Conditions with the aforesaid observation direction, this bail petition stands disposed of. Now next is item 7. In item 7, Tumar Bonajit upor aru tolat sob thike thakibo, khali in the submission of D. Das tat lekha Mr. D. Das, Learned APP for the state respondent, opposes the prayer of the bail and submits that from the
investigation is going on.
Submits that from the statement of where is that? He submits that from the statement of one co-accused, Ranjit De. Ranjit De. It is mentioned as Ranjit De here. Ranjit De.
Alias Guinea,
Alias Bhini, who is implicated in the FIR, has stated during interrogation that the petitioner helped him to flee from Guwahati to Calcutta. Stop.
It's a fact, my lord.
Stop. Then, before considering facts, agot likhiba that Considering the investigation is
is
substantially progressed,
substantially
further detention of the petitioner is may not be justified. Stop, and then the same.
Highly obliged. Obliged.
Disposed of. Huh?
In hearing, I
28,000.
Wait, please, Your Lordship.
29. I'm sorry, my case diary is not received.
Await case diary list on
Kusumara,
list on Mr. Das
19th of April.
19/4/24.
Interim may continue.
Interim, if any, shall continue till then.
Highly
31. 30. Miss Som 306 case diary, Mr. Bhattakur.
Yes, my lord, case diary received, my lord. Postmortem report also received, my lord. My lord, postmortem report is not conclusive regarding cause of death. And my lord,
She's on. The petitioner is on interim.
Is on interim.
Petitioner appeared. Statement recorded.
Statement recorded, my lord.
Anything adverse?
My lord, here incident occurred on 9/1/24 as per the, my lord. Thereafter, my lord, the victim here, this is, my lord, person died on, my lord, 16/1/24. But there is no dying declaration in the case diary. My lord, my lord, IO has stated regarding one, my lord, someone of the family members, my lord, recorded the audio of the, my lord, deceased person, and as per note of the, my lord, IO, this is the note of the
Lordship is aware that recording audio, there are certain procedures under the Evidence Act. So,
otherwise, my lord, he appears.
Yes,
Only I am
that
pointing
audio
out
cannot
that
be a conclusive
last portion,
proof.
my lord, regarding note of the IO. My lord. I am just pointing
In
it out.
absence of dying declaration and any other materials.
He appeared, statement recorded. His statement is also available in the case.
Who is Zakir Ali?
Zakir Ali is my lord, deceased, my lord.
And who is Kalakchuya?
Kalakoj, that is the name of a place. My lord, at the time of recording that video, the, my lord, deceased person.
There is otherwise, even from that recording video, it cannot be
yes,
ascertained
yes,
as why he consumed poison.
Yes, yes.
He's appeared.
He appeared, Lordship.
All right. Heard MS T. Som, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Bhattakur, Learned APP for the state respondent. Stop. This is an application under section 438 of CRPC seeking pre-arrest bail to the petitioner, i.e. Hatim Ali, who is apprehending arrest in connection with Hajo PS case number 10 of 2024 registered under section 306 of IPC. Stop. The facts of the the case of the prosecution is that on 16/1/2024, an FIR was lodged state alleging inter alia that the informant got to know that the victim has borrowed 50,000 rupees from the petitioner's husband on 10% interest, for which on 9/1/2024 the petitioner came to informant's house about 2-3 times and abused the victim with filthy languages. Stop. It is further alleged that thereafter the victim picked up the it is further alleged that thereafter the petitioner picked up the victim from home and the victim returned home after 1 hour and informed the informant that he became mentally frustrated. Stop. It is further alleged that thereafter the victim consumed poison. Stop. Pertinent to mention that by order dated 29/1/2024, the petitioner was granted interim pre-arrest bail by this court subject to conditions. Stop. The CD The case diary called is placed before this court. Stop. It is submitted by Mr. P. Borthakur, learned APP, for the state respondent that the petitioner, in terms of the interim pre-arrest bail order dated 29/1/2024, appeared before the investigating officer. Stop. He further submits that the statement of the petitioner has been recorded under section 161 CRPC and by the IO. Stop. He further submits that the materials collected, he further submits that there are no adverse materials at this stage collected by the investigating officer against the petitioner. Stop. Accordingly, this court is of the considered view that custodial interrogation of the petitioner may not be necessary for the ongoing investigation. Stop. As such, the interim pre-arrest bail granted by order dated 29/1/2024 is hereby made absolute, subject to following conditions. Those two conditions: corporate inducement. With the aforesaid observation direction, this AB stands disposed of. Return case diary.
Lordship, I take Lordship indulgence, Lordship. In IA 92, already there was certain mistake.
In IA?
Lordship, one mistake was there in the case number to be 20 instead of 10, Lordship. This case number, Haju PS case number, has to be 20, Lordship.
Case number 2020. 20/2020.
24.
Stop. It is Mr. K.K. Parashar, learned APP, submits that the charge sheet has been filed in the meantime by CS number 42/2024 dated
23/2/24
dated 23/2/2024
under section 457 378 511
under section 457
stroke 376
511 of IPC.
No, 511.
511 11
Sorry.
of IPC. Today, I think there is some difficulty of hearing from both the sides because of the glass or what, I don't know. Even I'm having difficulty to understand the submissions from the other side. Anyway, stop. Considering the aforesaid endorsement, this court is of the considered view that this anticipatory bail application can be disposed of with the direction that the petitioner shall appear before the
Learned SDJM.
North Salmara, Abhayapuri, within a period of 15 days from today, and till then he shall not be arrested. Stop. Upon his appearance, the trial court, the learned trial court, is at liberty to consider the prayer of bail on its own merit. Disposed of with the aforesaid observations.
32 minutes.
CD not
received.
await CD list on
9th of April.
9/4/2024 interim. Interim, if any, shall continue till then.
Item 33.
Yes, Ms. Begum, CD.
Scan copy was there, Lordship.
LCR.
Lordship. Only cognizance has taken as per SARCIT, Lordship. Cognizance have been taken as per SARCIT under section 120B 498A 304B.
Under
120B.
Yes.
As per SARCIT, Lordship.
Yes.
498A 304B 34
304B.
B.
So investigation is completed.
Investigation completed, Lordship. It is fixed for appearance. First date he could not appear. On the next date is fixed on 22/5/24.
22/5/24.
24. And he is absconder, Lordship. SARCIT shows as he is absconder.
Let him appear.
Lordship, he is absconder, Lordship. So he will appear. Court will decide, Lordship, as per law.
May I submit, sir, Lordship? May I submit?
What more you want?
Lordship, FIR was lost in 2017.
We are allowing you to appear before the trial court.
Lordship, in the meantime, I may put it.
Till then,
Lordship.
in item number 32. Is it 32? 33. You are Mr. J. Hussain.
R. Islam, Lordship.
Mr. R. is heard. Mr. R. Islam, learned counsel for the petitioner. Stop. Also heard Mr. Also heard MS A. Begum, learned APP for state respondent. Stop. This is an application under section 438 CRPC for granting of pre-arrest bail to the accused petitioners, i.e. Dulal Kaji and Sukhjan Nesha, who are apprehending arrest in connection with PRC case number 1462/2023, registered under sections 306-34 IPC, arising out of Fakirganj PS case number 52/2017, registered under sections 120B, 498A, 304B, 34 IPC. Stop. It is submitted at the bar that charge sheet has been the trial court has taken cognizance.
Lordship.
The trial court has taken cognizance of the offence
As charge sheet has submitted.
as charge sheet has been submitted under
that-
section 120B, 498A, and 304B. Stop. It is further submitted that the next date fixed before the trial court is on 22/5/2024. Stop. Mr. R. Islam, learned counsel for the petitioner, submits that the petitioners are willing to cooperate, are willing to appear on the next date fixed and appear regular, and assures that they will be appearing regularly before the trial court as and when the matters is fixed. Stop. Considering the aforesaid, it is directed that considering the aforesaid, this anticipatory bail application is disposed of with the direction that the petitioner shall appear before the court of
Lordship, it is a session triable section.
court of CJM Dhubri,
Session triable.
court of session judge Dhubri on 22/5/2024. Until then, he shall not be arrested. Stop. It is needless to clarify that upon his appearance, the trial court is at liberty to consider the prayer for bail on its own merit. Disposed of.
Applies.
Item 35.
Maitri, আমি disposed of একটু 32 আগতে mention আছিল না 35. Yes.
Your Lordship. Your Lordship,
CD
received no?
Yes.
Your Lordship, 438 bail application, Your Lordship. Your Lordship, में Perus Annexure 1, page number 13. That was Your Lordship.
Page number
13, Annexure 1.
Yes.
Your Lordship, this is an agreement, Your Lordship, in between the...
Where is the FIR?
FIR, Your Lordship, FIR is at page number 17, Your Lordship.
Yes. $164 of the victim is there?
Yes, my lord. 164 received, my lord. Initially, my lord, there was love affair between the my lord, victim and the accused person, and thereafter, on the pretext of marrying her, my lord, on 19/12/23, the accused person took the victim to my lord Romania court, and thereafter, my lord,
They executed an agreement, Your Lordship.
but that agreement is not available in the case diary. Thereafter, my lord, he took him to his house also, and thereafter, my lord, keeping him for her for 2 days. My lord, as per my lord, 164 statement on.
In the FIR itself, she has said cleverly taken her signature in a notary.
Yes, Your Lordship.
Yes. Further?
Further, my lord, as per her 164, he also my lord, forcefully committed my lord, the physical intercourse with her. My lord, that is the allegation.
Custodial interrogation?
And thereafter, my lord, by leaving her, he my lord fled away from.
Custodial interrogation required?
Probably on the basis of one thing. Further custody, I will leave it to lordship, my lord. Otherwise, my lord, her 164 statements she implicated.
They were in love affair, your lordship.
Initially, there was love affair between the.
And your lordship.
Considering that only, I have put the question. Otherwise, this court would not have granted anticipatory. He was not on interior, right, Mr. Bhattacharya?
Not on interior.
Heard Mr. S. Paul. Heard Mr. S. Paul, learned counsel for the petitioner. Stop. Also heard Mr. P. Bhattacharya, learned APP for the state respondent. Stop. This is an application under section 438 CRPC for granting pre-arrest bail to the petitioner, namely Injamul Haq, alias Injamul Haq, who is apprehending arrest in connection with Barama Police Station case number 150/2023, registered under section 294-323-376-34 IPC. Stop. The case of the prosecution is that an FIR was lodged on 26/12/23. On 26/12/2023, alleging inter alia that the accused number 1, i.e. petitioner, was in relationship with the informant since last 4 years. Stop. It is further alleged that after the informant attained the age of 19 years, the petitioner incited her to get married. However, stop, don't say however, stop. It is further alleged that the informant cleverly took her to Rongia, wherein the informant told her that he would marry her, and thereafter called her father from Rongia. Stop. It is further alleged that the petitioner cleverly had taken signature in a notary. Stop. It is further alleged that thereafter the petitioner took her to his home at Rongia, where he kept her for 2 days and raped her and assaulted her and left the house, leaving her in his house. Stop. Mr. S. Paul, learned counsel for the petitioner, submits that the allegations levelled are totally incorrect and the petitioner has been wrongly implicated in the offence alleged. Stop. Mr. P. Bhattacharya, learned APP, on the other hand, strongly opposes the prayer for anticipatory bail. Stop. He further submits that the statement of the informant has been recorded under section 164 CRPC. Stop. He further submits that the investigation has substantially progressed. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation has substantially progressed and the statements of the witnesses, including the victim / informant, has already been recorded. Stop. Considering the facts and circumstances of the case, this court is of the considered view that custodial interrogation of the petitioner may not be necessary at this stage. Stop. Accordingly, it is provided that in the event of arrest of the petitioner named above in connection with the aforementioned case, he shall be released on pre-arrest bail of bail bond of rupees 30,000, satisfaction arresting authority, subject following conditions. Number 1, appearance within 10 days and inducement. With the aforesaid direction observation, it stands disposed of.
Oblige, your lords.
Item 37.
Yes.
If it is an application.
FIR is at page?
Page 12, my lord.
Page 12.
My last occasion, my lord, medical report was called for.
Injury report was called for, my lord. Injury report not yet received, my lord.
My lord, it cannot be received, my lord. There is no any such incident happen, my lord.
Hmm?
There is no any such incident happen. That's why my last occasion, injury report could not be received, my lord.
Mr. Bhattakur?
Offence is, my lord, registered under, although, my lord, there are allegations from the, it seems that from the FIR to be very serious, my lord. But FIR is registered.
Last chance, when can you have it? After that, we will not be waiting any longer. We'll thereafter consider on the materials.
Yes, my lord.
My lord, another important thing is that, my lord, incident took place at 10:30 p.m. at 10:30 p.m. on 14 to 2000, and my lord, 24 near the police station. Had there been any such incident happen, my lord,
Yeah, we'll give them a last chance, anticipatory bail.
Yes, my lord.
Day after, on today is 18, my lord, on 19.
19, I think there are many matters fixed.
20, Friday, my lord.
Friday, Parim?
Friday, 22nd.
22nd.
Last chance is given to the to the state respondent to produce the inquiry report as called for by this court by order dated 12/3/2024.
I have not found any requisition actually, my lord, sending the victim for medical examination.
So then I will consider.
Otherwise, my lord, from the case diary, although my lord, allegation seems to be serious, my lord, I have gone through the entire case diary. Offences are registered under section 324, 325, and my lord, 392 is also there regarding, my lord, that the accused person looted an amount of rupees 12,500 on that day of occurrence. My lord, what happened, my lord, from the entire case diary on the day of, my lord, on that day, my lord, Saraswati Puja was going on, and the my lord victim and his wife, my lord, went to to see the my lord Saraswati Puja at that point of time, and thereafter, my lord, between two my lord accused persons, my lord, there is some fight between groups of some my lord boys, and thereafter, my lord, at that point of time, while the victim and his wife returning from that Saraswati Puja, my lord, then someone has, my lord, in between that, my lord, fight, someone has, my lord, hit the husband of the my lord, the present husband of the informed. Of the my lord, of the present informant, that is and thereafter, my lord, while the my lord wife of the husband trying to my lord save his then
her
at
husband.
that point of time she also, my lord, as per the allegation, my lord, all other allegations that 12,500 looted, and she was also, my lord, assaulted by the other accused. But from the case diary, although some of the witnesses stated, but regarding that 12,500, section 392 is also there.
Mr. Bhattakur, has anyone named the petitioner?
Yes, because, my lord,
petitioner
later on, my lord,
what is the allegation? The petitioner is present or the petitioner was involved?
Yes, petitioners were present because, my lord,
and what about the involvement?
Involvement because from the video footages, my lord, one video footage is also there. Then the my lord victim, his husband and wife stated that B2 and the present accused person, both all these accused persons were present there.
The presence is another thing. Is the petitioner involved? Because you see, the petitioner is saying that there is no injury, and the informant also has not gone for medical.
From the case diary, my lord, custodial interrogation probably may not be necessary, my lord. Although,
All
my
right.
lord, FIR from the contents of the FIR
Very well.
seems to be, my lord,
It is his own
Heard Mr.
FKR Ahmed.
FKR Ahmed, learned counsel for the petitioner. Stop. Also heard Mr. P. Bhattakur, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting pre-arrest bail to the petitioners, i.e. Ashutosh Kumar, alias Banti, and Prem Sahini, alias Prem, who are apprehending arrest in connection with Fatasil Ambari PS case number 59 of 2024, registered under section 325, 324, 354 within bracket B, 392, 34 of IPC, corresponding to GR number 836/2024. Stop. The case of the prosecution is that
Page 12.
page 15, right?
Yes, my lord.
Is that an FIR was lodged on 15/2/2024 alleging inter alia that on 14/2/2024, after the informant closed his hotel, and was going with his wife to Kushal Kanwar Path, Kali Mandir, to visit the Saraswati Puja, and after returning therefrom, some people started beating the informant from backside on his head, shoulder with rod, dowel, bamboo and knife, and dragged him and started hitting him with helmet, etc. As a result of which he fell down and sustained severe injuries. Stop. It is further alleged that when his wife interrupted them, when his wife tried to interrupt them, she also sustained injuries. Stop. Mr. F.K. R. Ahmed, Learned Counsel for the petitioner, submits that the petitioners are totally innocent and have been falsely implicated in the offence. Stop. He further submits that the petitioners was merely present at the place of occurrence and accordingly was,
and there is no any such incident took place.
and he also submits that no incident as alleged in the FIR has taken place. Stop. Mr. P. Borthakur, learned APP, on the other hand, strongly opposes the prayer of anticipatory bail. Stop. He submits on the basis of the materials available in the case diary that that the statements of witnesses have been recorded.
Yes, recorded.
Stop. He further submits that the investigation has substantially progressed. He further submits that it appears from the materials available on the case diary that the petitioners were present at the place of occurrence. Yes. Stop. He further submits that the informant has refused to be medically examined.
No, my lord, the informant has not, but I have not found any requisition that police.
He further submits that there is no requisition for medical examination of the informant stroke victim available in the case diary. Stop. Pertinent to next paragraph. Pertinent to mention that by order dated 12/3/24, this court had directed had called for the inquiry report. Stop.
Injury report.
Injury report. Stop. However, today when the matter was fixed, no injury report has been received. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Considering that the investigation has substantially progressed,
yes,
this court is and also by taking the totality of the circumstances of the case, this court is of the considered view that custodial interrogation of the petitioner may not be necessary for the ongoing investigation. Stop. Accordingly, the petitioners named above. Accordingly, it is provided that the petitioners named above, in the event of arrest, in the event of arrest in connection with the above noted case, shall be released on furnishing of bail bond of rupees 30,000 each, satisfaction of the arresting authority, with subject to following conditions: number 1, appearance 7 days; number 2, inducement. This disposes of the anticipatory bail application.
Obliged.
For orders, item 38.
Dispose there.
My lord, here
Yes, Mr. Chaudhary.
Yes, my lord. As per direction of the Honorable Court, my lord, we serve the copy to the informant, my lord. Your lordship kindly peruse the order dated 14/3/2024, my lord.
Yes.
Office note, my lord.
Service report R2 has been received and the same is tagged. So service is complete.
Yes, my lord. Now,
We can then post it for admission.
no, my lord. I have a bail application, my lord.
So, my lord, yes, service after service for the done has appeared. In the POXO case, my lord,
It's a POXO case.
Yes. So, my lord, from amicus curiae, someone has to be appointed, my lord.
Do you have the list legally?
Otherwise, it is a very clear case, my lord.
No, but it's that
Yes, sir.
Deepak Nayak, Mr.
Yes, sir.
Chaudhary.
Yes, Doctor say her age is 21 years, man.
Mr. Chaudhary,
Yes,
you are aware of Deepak Nayak.
yes, man. Deepak Nayak, I know.
The practice directions have been laid
There's a
down.
notification also, my lord.
Yes. So there is a list of legal aid councils. We'll appoint one of them.
My lord.
It appears from the office, it appears from the office note dated 14/3/2024 that service in respect of respondent number 2, who is R2, Mr. Chaudhary, informant,
Yes, yes, sir.
who relation with the victim?
My lord, he is the brother of the victim.
That again, there will be a difficulty because
Now the victim has married, my lord.
no.
And I can show your lordship that she is a 21 years.
All that is different. The act envisages notices on upon the parent
Yes, sir.
or victim or support person.
Yes, my lord.
Now he is a brother.
My parents has already been expired. So brother has filed the FIR, my lord.
Otherwise,
Should we, before we appoint someone, should we try to
My
serve it on the victim through the jurisdictional IO
my lord,
or
yes.
the SP?
My lord, that is as per the notification now.
Correct.
my
As per that notification, that is what is to be done.
Problem is that, my lord, she is not living in that place, my lord.
Where is she?
I don't know, my lord, because family member not inform us.
No, that let the IO furnish that report.
Yes, my lord.
The IO, the SP, jurisdictional SP will give us the report. If the jurisdictional SP says she cannot be traced, then this court will do what is to be done.
My problem before your lordship is I have gone to the Deepak Nayak case, my lord.
Yes. You have a copy.
That judgment is not available. my lord.
Anyway,
But problem is that, my lord, informant is there. We serve the copy.
no, that will not be. Mr. Chaudhary, sorry. That is not the spirit of Deepak Nayak.
Yes, well,
It's very clear. Very well.
Someone.
In fact, before on 14th only, at the time of issuing notice, if this was pointed out to the court, perhaps on 18 January, you could have taken it through the jurisdictional SP because R2 is already
One
informant.
thing is that my right under Article 21 has been violated also. My this
Very well.
procedure, my lord. If I am behind the bars for last 1 year,
Mr. Chaudhary,
yes, my lord. Suppose it
kindly
become 10 years,
bear with this court
process,
right
my
now.
lord.
Let the procedures be completed first. We are bound. This court is bound by the practice direction issued by the division bench. Correct, Mr. Chaudhary?
Yes, my lord. Your lord is absolutely correct.
Likha.
But it is the duty
It
of the police
appears
to take
from the office note dated 14/3/2024 that service report in respect of respondent number 2, who is the informant stroke brother of the informant, has been completed. Stop. However, in terms of the practice direction issued by the division bench of this honorable court in the case of Deepak Nayak versus State of Assam, it is mandatory in all matters relating to POXO that the service and the copy of the petition be furnished to the victim stroke parent stroke support person, as the case may be, through the jurisdictional police officer. Stop. In view of the above mandatory directions, let a copy of the criminal appeal and along with the interlocutory application be served to the jurisdictional police station through the office of the public prosecutor in order to furnish the same to the victim.
Jurisdictional police station or what? We do not know.
Jurisdictional police station where the IO, the investigating officer.
Yes, ma'am.
Yes. That is a jurisdictional police station, or I say investigating officer, because you see sometimes the IO changes.
Yes, ma'am.
That is why I use the jurisdiction.
Yes, sir. The jurisdictional police station and that within a period.
Mr. Chaudhary, you have broken my flow.
Yes, sorry.
Have patience. Let me complete the
Yes, my lord.
sentence.
Yes, my lord.
Ki likhila? To the victim in accordance with the aforesaid practice direction issued by this court. Stop. Thereafter, the jurisdictional police jurisdictional police officer shall furnish a report to the office of the public prosecutor as regards the status of such service. Stop. Matter list after 2 weeks on a date to be fixed by the registry. Yes, Mr. Gogoi.
My lords, I'll seek some accommodation for
Yes.
Such a petition was disposed of, my lord, directing me to appear within 15 days. But that 15 days time is over, my lord, due to some family problem, my lord. Another 10 days time.
Where have you stayed at the ground?
My lord, 15 days, that direction was of 15/11/23. He has to appear before 30/11. Now in between, my lord, not 15 and in between, another 2 months, 3 months gone, my lord.
You see, orders for extension cannot be granted mechanically. You have disobeyed the liberty that has been given to you. And you expect this court to exercise inherent power in favor of you? This will not be done. You want to withdraw, you can withdraw. Otherwise, I'm dismissing it.
My lord, we have no option, my lord. We are ready to appear, my lord.
You should have appeared earlier. You waited since November 23. Is it correct, Mr. Parashar?
My lord,
Order was of 15/11/23.
Correct.
My lord, my humble prayer is that very short period, my lord, at least 3 days time may be given, my lord.
No.
Because, my lord, the petitioner will have, my lord, no option, my lord, to appear, my lord.
Yes, you appear. I don't see any other option for you also. Why you are not appearing? You appear. You have violated. You will have to say. You will definitely have to face the consequences now.
Earlier occasion, my lord, while the criminal petition was.
All right, Mr. Counsel, I've heard you.
My lord, only 2-3 days time.
You are Mr. A. Ali?
My lord.
Heard, Mr. A. Ali, learned counsel for the petitioner. Stop. Mr. Counsel, by laughing or smiling, you will not get an order from this court. If you have merit, definitely this court will give you the order. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent. Stop. This is an application for extension of time to appear before the learned SDJM S. Darang Mongoldoi as per this Honorable Court's order dated 15/11/2023 in criminal petition number 1179 of 2023. Stop. Where is the order, Mr. Parashar?
My lord, page 10 of the IA.
It appears that this court, by order dated 15/11/2023 in criminal petition 1179 of 2023, while disposing of the said criminal petition,
Direction page 11. Last
keeping
direction.
in mind the submission made on behalf of the petitioner that the petitioner is willing to appear before the learned trial court, comma, disposed of with a direction that the petitioners shall appear before the learned trial court within 15 days, and to facilitate their appearance before the learned trial court, comma, the pending NBWA issued against them shall be kept in abeyance for next 15 days. Stop. Mr. Next para, Mr.
Ali.
A. Ali, learned counsel, but the petitioner submits that due to family problems. Due to family problems, the petitioner could not appear within the stipulated 15 days time period given by this court, and accordingly 6 extensions. Stop. Mr. K.K. Parashar, learned APP, on the other hand, strongly opposes the prayer and draws the attention of this court that since 15/11/2023, the petitioner, after getting the order for appearance before the trial court, chose not to do so till date. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that this court, on the basis of the assurances and endorsement made by the learned counsel for the petitioner disposed of the criminal petition by allowing the petitioner to appear before the trial court to facilitate their appearance before the trial court. Stop. As such, no case for extension is made out. Stop. I stands dismissed.
Item 41.
Yes.
My lord, there is a criminal petition, my lord, under 482 CRPC, my lord. Here, my lord, as per the office note, my lord, already LCR has been received, but the service report is awaited.
Await service report.
Earlier, my lord, the instance was taken, my lord, and earlier also, my lord, one criminal petition was filed, my lord, prior to this criminal petition in respect for quashing of the FIR, my lord. But during pendency of the criminal petition, my lord, the case was succeeded, and my lord, learned court belonged to cognizance also. So ultimately, that criminal petition was withdrawn with liberty, and this petition was filed afresh now. So, for quashing of the entire from FIR to the cognizance order, in the earlier petition, my lord, the notice was served. The respondent side appeared, my lord.
But today the service is not complete.
So the office note is concerned not completed, but
So very well, then await service report, list after 4 weeks and a date to be fixed by the registry.
my lord, that will be very long.
2 weeks.
Well, on 28th, my lord, not should be fixed date.
On 2 weeks after, on a date to be fixed by the registry. Next.
My lord, I may be directed to take raise step through the concerned PS, my lord. Otherwise, my lord,
All right. In the meantime, petitioner is given liberty to take fresh steps through the concerned police station.
Lord, should be fixed a date, my lord. Otherwise,
All right. Next.
All right.
Yes, Ms. Dev, what is this transfer petition?
Yes, Lordship, in this case, last occasion on 23rd February, this Honorable directed the petitioner to apply the Honorable Court regarding pendency of the status of this FIR.
Yes.
By the,
Mr. Parashar, have you received the instructions?
Lordship, in this case, I have filed an affidavit stating about the pendency of the case.
Mr. Parashar, have you received the affidavit?
Scan copy perhaps call. I don't see the CD copy.
No, it says the
in order sheet it is reflected. Order dated 23rd.
scan copy, that's right. Scan copy of the record from the court below. That has come. It has come. And what is this affidavit that you said you have filed?
I have filed regarding the status of the FIR filed before the Udalguri police station.
Have you received a copy of that affidavit?
Yes, without, yes.
Huh? That is what I am asking, because you see, Ms. Dev, sometimes these are served in the offices, but you don't have it right now. You have a look at it, we'll fix it. Why is it come for orders today?
Last occasion case was listed.
Service of the restaurant number 2, my lord.
No, because it's come for orders, that's why.
Yes, Lordship. It was returnable on.
Neither AD card nor unserved notice service report in R2. So R2 is still awaiting.
Yes, Lordship.
Await service report then after 2 weeks. We'll keep your affidavit is already on record. Await service report. Stop. In the meantime, the LCR has been received. Same shall be retained in file.
Regarding interim prayer, may be considered on the next day.
Next day, that prayer first day, if it is given, it's given.
Yes, Lordship.
Subsequently, we cannot give you that order.
Lordship,
Anyway, next.
Lordship, kindly fix the date on 3rd of April.
3rd April. 3rd April. All right. Yes, Mr. Jain.
May I please, Your Lordship?
Why is this criminal petition for
My Lord,
orders?
this criminal petition arising, I am briefly submitting.
Why is
my
it
lord.
for orders?
Orders, my lord, for service of the notice, my lord. A notice has already been served as per the office note, my lord.
Duly served.
Duly served, my lord.
So we fix it for admission?
My lord, small prayer, my lord. 125 proceeding was initiated by
It's the only thing you see, it says 14.3, it has been served, so we'll fix it for admission. On that day, if they don't appear, you make your submissions. Today it has come up for orders. It appears from the office note dated 14/3/2024 that service in respect of the sole respondent has been received back from the Additional District Magistrate Kachar corresponding file at us. Shantana Bhattacharjee.
My lord. Bhattacharjee of the Chakraborty.
Panorjit. Rafna Hassan.
It is in Bengali, my lord.
Yeah, that is what.
I have gone through the report.
Could you read?
Yes, my lord.
What does it say?
It is served as per.
It says it is served.
Sir.
And
Last fourth line.
And her signature is there.
Yes.
All right. After duly being served. Return back question. After duly being served. Stop. As such, service in respect of the sole respondent stands completed. Stop. List this matter for admission on
1/4, my lord.
date. Give a date.
Fix a date.
25/4/2024.
Only a small prayer, my lord, that as per the direction of the lower court below, my lord, I had to make a payment. The one date may be allowed by the lower court below. Earlier order is there, my lord.
No. Next.
Obliged.
This is an IA to condone delay of 30 days in preparing
30 days?
30 days.
Yes. Who is opposing? Anyone opposing? 30 days. Mr. Parashar, are you there in this case?
We are there, but
Private informant has died. Poxo no.
It's a POXO matter.
No, madam.
Only state. Respondent is only state. Any objection?
No, madam.
What is the ground for 30 days delay?
Madam, the poor person matters cannot arrange the resources.
All right. Heard Mr. B. Gogoi, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent. Stop. This is an application for condonation of the delay of 30 days in filing the connected criminal appeal challenging the impugned judgment and order dated 13/10/2023 passed by the learned session judge Morigao in session case number 87/2016, thereby convicting the applicant under section 304 part 2 of the IPC and sentencing the applicant to undergo rigorous imprisonment for 5 years and also to pay a fine of rupees 20,000 in default to suffer simple imprisonment for 6 months and further allow the applicant to go on bail. Stop. The facts of the case is that
Paragraph 4, madam.
the applicant was convicted by judgment and order dated 13/10/2023 in session case number 87/2016. Stop. However, the petitioner being from a financially weaker background, the petitioner is inside the jail, right?
He is in jail.
The petitioner's father, who is aged about 80 years old, could not come to Guwahati for filing the instant case and the wife of the applicant, who is the only person to look after the father of the applicant as well as children, also could not come within the stipulated time for filing the appeal. Stop. The elder brother of the applicant managed somehow to contact the present counsel and handed over the brief of the case. And after arranging the professional expenses, the instant appeal was filed. However, while doing so, a delay of 30 days has occurred. Stop. I have heard the submissions made at the bar and have perused the material and perused the averments made in the condonation application for condoning the instant delay, for condoning the said delay of 30 days. Stop. It appears that the grounds averred in paragraph 4 of the condonation application are sufficient grounds. Stop. As such, in the interest of justice, this court is of the considered view that the delay of 30 days is required to be condoned. Stop. Accordingly, the delay of 30 days is condoned. The IA for condonation application is allowed. Stop. Criminal appeal needs to be registered.
Yes, sir.
In the criminal, that order will be in the criminal appeal.
No. In the IA,
in view of the aforesaid order, registry is that let the registry register the connected criminal appeal and place the same before the bench. Disposed of. IA to dispose.
Yeah, please, Your Lordship.
Yes, Mr. Chaudhary.
Lordship, this IA is for condonation of 32 days delay.
How many? 32?
32 days delay.
Who is notice has to go?
Notice has to go because these are private persons, Lordship.
Heard Mr. R.K. Dev Chaudhary, learned counsel for the applicant.
Lordship.
Stop. This is an application under Section 5 of the Limitation Act 1963, praying for condonation of 32 days in preferring the connected criminal revision petition. Stop. Issue notice, returnable 2 weeks.
Lordship, this is Calcutta. It may be a bit longer.
Returnable 4 weeks. Stop. Registered post AD within a period of 3 days from today. List accordingly.
So, Lordship. For hearing Article 46.
Thank you.
May I please, Lordship? My Lord, the last occasion, my Lord, the Lordship directed me to check up the law section under which the impleading application has been filed. Impleading for
that case.
Moinul Haq.
Yes.
To be impleaded. My Lord, there is no provision I have got, but under Article 4, exercising the power, under 482, my Lord, your Lordship may
Inherent power.
To implead the party of the husband of the accused husband of the opposite party number 2.
No, but in CRPC it is mentioned in a case who are parties. There is some provision, right, Mr. Das? In a criminal proceeding, this is an FIR, right?
FIR.
Now, in quashing of this FIR, they want the husband of the informant to be impleaded.
Husband is the accused number 1 in the FIR.
That could be, but
right. Implead petition. I have filed a petition for implead.
So, in the FIR against which you are seeking quashing,
My Lord,
you are seeking quashing of an FIR.
Quashing, yes, charge sheet as well as the FIR, my Lord.
And today the IA is that impleadment. IA 46.
Yes.
Is the impleadment IA?
Yes.
The IA, yes.
My Lord, otherwise, my Lord, wife has compromised the matter with the husband. There is a compromise deed also. I have filed. Another miscase, affidavit, my Lord, I have filed. Along with the compromise deed, my Lord.
Do you have filed how many IA?
But husband is the not petitioner.
This is not IA, my Lord, this is the affidavit.
IA 52 is the IA for impleadment of the petitioner numbers, the husband.
IA 46 is the impleadment.
Sorry, IA 46.
Yes,
yes. IA 46 is the impleadment application for the husband as respondent number 6. Correct?
My Lord.
In the criminal petition.
Yes.
That is this.
My Lord.
Now, you are saying he is an named FIR accused.
Yes.
Where is the FIR?
My lord. FIR is that page, my lord.
Page 18, my lord.
Page 18, my lord.
Translated copy.
Translated copy. Page 18.
Yes,
My lord,
which
here, name of the accused, Moinul Haq.
He is the husband.
He is the husband, my lord.
He is the husband.
My lord.
You want impleadment of Moinul Haq?
My lord. My lord.
Now, these petitioners together had filed this petition, criminal petition for quashing.
Washing.
At that time, this person did not join them.
Join them because, my lord,
And
husband.
now they want to join. Is that permissible, Mr. Das?
Yes, it is permissible.
On what? No, but this is a criminal petition. If they wanted, he should have come. Otherwise, he should come by way of a separate petition then.
There is also one way, my lord.
He should have been there.
Now he has to file. This Moinul Haq may file one intervening petition.
There is no... Why did he not join them? Where are those reasons?
Because he was living separately with his wife.
So that's
why, my lord, I am not included in the earlier petition.
But now,
because all others,
Mr. Day, now when there is a compromise, you are saying, now because there is a compromise, you want that he should also get the benefit.
Compromise with all the accused, my lord.
Correct. So he also now want to take that benefit. That is why he wants himself to be
He
impleaded.
has compromised, so my lord, he will get the benefits. He has to get the benefit because, my lord, may I submit the decision, my lord?
What decision you have?
My lord, if the husband and wife settle the matter, my lord, this court should be liberal.
That is a different thing.
Dispose of the matter.
But here about impleadment, do you have any authority about impleadment in criminal proceedings? Impleading as a petitioner, because this is not provisions of CPC will not come here where you can add or join a petition plaintiff.
Article, my lord, 482, my lord, your lordship has inherent
No,
power.
but that is not that inherent also. We'll have to exercise it with circumspection.
For the ends of justice, my lord, that is necessary, my lord. I beg to submit, my lord, paragraph 11, 12, 13 and 14, my lord.
তাৰ নামত এখন পিটিশন ফাইল কৰি নিদিয়ে আছে এইবিলাক কিয় কৰি আছে এখন তাক মাতি আনি পিটিশন ফাইল কৰি দিয়া
Absolutely, Mr. Das is advising you correctly. This court can hear the conversation.
Sorry.
No, but I think Mr. Das is correctly advising.
And Lordship, so far as my knowledge goes, Lordship, there is no specific provision in the CRPC for impleadment, Lordship.
True.
There is a discretion
Now,
of the court, Lordship, to implead.
just because it is not there doesn't mean under 482 this court will do it, right? There is also another way of doing it, because there is no such circumstances which has been brought to the notice of the court which prevented you to be joined as a petitioner. You could have been joined as a petitioner. You chose not to. Today you want to join, and it is not you. You are appearing this side. The petitioner wants you to be joined, it looks like. Now, if you want yourself to be joined, you can file another petition and tag it along with this. There is no harm in doing that.
Perhaps that will be the right course of action.
Correct.
Let him.
Someone let the matter may come up next week. In the meantime, I will.
You do it.
My lord.
So I will not do anything. We'll keep this. You file it. That day we'll dispose it down. That's the most easiest way, Mr. Day. All right. As prayed for by the learned counsel for the parties, list this matter. When do you want, Mr. Day? After 2 weeks on a date to be fixed by the registry. It will write you order.
Apply.
আমি শর্টকাট করে বিচাৰিছিলো
এইটো অফ কৰি দিলে হ'ল
হেৰি জাজমেন্টৰ কপিটো থাকিব নেকি
লাগে নেকি আপোনাৰ
হ্যাঁ
লাগে নেকি আপোনাৰ
নালাগে নালাগে থাকক থাকক থাকক
চাও আৱাজ শুনা পাই আছো কিয় স্টপ করে দিলে হচ্ছে এটা এন্ড করে দিলে হলো এন্ড customer that